So today I'm here to talk to you about the fundamentals of intellectual property. And with today's presentation, I'll begin by discussing some of the various types of intellectual property. I'll then go on to discuss some of the considerations you may have in terms of what and when to file. And then finally, I'll conclude with some common problems that will sometimes occur with different companies in regards to protecting and enforcing their IP. So generally, a company will have three different types of property. So for real property, that would be, for example, office space either leased or owned by the company. There's also personal property, such as a company's inventory, their computer systems, and their furniture, for example. And finally, there's intellectual property, which is what we'll be talking about today. So what is intellectual property? Intellectual property is an intangible property right that for many companies will represent a majority of that company's value. So just to give a couple of quick examples of the potential dollar value involved with IP rights, when Nortel Networks sold its patent portfolio, they sold it for $4.5 billion. In another deal, Google purchased the patent portfolio of Motorola, and to obtain that, they had to pay $12.5 billion. So these patents are so valuable because they allow the holder to have a monopoly on what's covered by the patent's claims. So for a patent directed to a technology in a market worth billions of dollars, it's easy to understand why those patents would have so much value. Other forms of IP other than patents, of course, can also have value. Trademarks, for example, are very useful for branding for a company. If you think about the value of a well-known trademark such as the Starbucks logo, for example, it's a powerful message to consumers that is essentially a shortcut for relating the source of goods and services. For example, if someone's driving down the street and they see a Starbucks sign, they'll have a good idea right away of the type of product and service that will be offered at that coffee shop. Whereas if they see a sign for a company they're not familiar with, obviously that information is not conveyed. So it's a quick identifier to the consumer. So in this presentation, I'll first talk about the different classes of intellectual property, two of which I've already mentioned, patents and trademarks. Then I'll discuss some strategies and considerations for protecting that IP. And finally, I'll discuss some of the pitfalls that relate to the IP that are routinely encountered that relate to ownership and control. So starting first with the types of IP, there are four main categories. There are patents and trademarks, like I've already mentioned, but there are also copyrights as well as trade secrets. And I'll be talking about each of these in turn. So first of all, we have patents. In many instances, patents can make or break a company, especially in today's economy where technology is paramount. In a crowded field, for example, let's say there's a marketplace with a lot of players, that can prevent, if there's a minefield, so to speak, of patents, a patent thicket, if you will, it can prevent a new entrant from entering into that market. On the flip side, if you're one of the companies that owns one or more of these patents, it's obviously very beneficial for you because it gives you a tool to exclude those other companies. So other than excluding those companies, another benefit is that if you own one of these patents, of course, you can allow them into the market, provided that they pay you a hefty licensing fee. So what exactly is a patent? In simple terms, as I already mentioned, it's an exclusionary right. On the most basic level, it gives the patent holder the right to exclude others from making, using, offering for sale, or selling the invention throughout the United States, or importing that invention into the United States during the enforceable term of that patent. If a person has a novel, non-obvious, and useful idea, they can obtain a temporary monopoly, which is what a patent is, for that idea in exchange for a disclosure of the invention to the public. So it's a trade-off. You get the temporary monopoly and the public gets the disclosure of the information to use it once the patent term expires. For utility and plant patents, that term is a period of 20 years from the earliest filing date. So for example, if you file the patent application and it takes 3 years before it's allowed, you would then have the remaining 17 years as the exclusive term of the patent. For design patents, that monopoly will last 15 years from the time the patent is granted. Generally speaking, the application will consist of a specification that includes a background section to describe the state of the current art and any current problems that the invention may address, a description of any figures or drawings that are included in the application, a detailed description of the invention, any figures or drawings, and then finally, most importantly, a set of claims that covers the scope of the patent application. The claims are really the most important aspect of the application because they are what determines the scope of your monopoly. Really, it comes down to the claims, and the rest of the specification is just a means of supporting those claims. There are three primary types of patents. I have four listed here, but provisional is really just, there's no such thing as a provisional patent. There is a provisional application which can be converted into a utility application, which I'll describe in just a moment. There are also design patents to cover non-functional ornamental designs and plant patents. But really, if you think of a patent, most people will be thinking of a utility patent. That's the most common type. For provisional applications, they are a really inexpensive way to get your foot in the door to secure a filing date. The application is not examined by the USPTO. There are no formatting requirements for the application itself. For instance, a lot of time, for example, dealing with a university, a professor may submit just a manuscript, a draft of the manuscript before it gets submitted for publication, as long as that manuscript includes all of the relevant details. So there's no formatting requirement for what needs to go into the provisional application. In some circumstances, an inventor may be unsure whether the invention is worth pursuing, in which case they don't want to lose the priority, but they don't necessarily want to commit to the full utility application yet. And so that's really what a provisional is useful for. It gives you a one-year window during which time you can then convert it into a utility application. Sometimes, for example, the inventor may want to assess the market more before putting in the resources to file the full utility. Or they may want to use the provisional application as leverage for getting investment in their company, or even to license the technology with the license covering any utility application claiming priority to that provisional. And so, as I said, if they decide that it's worth pursuing a utility, that it's worth converting this provisional, then they have 1 year to do so. So for a utility application, unlike a provisional, it is examined by an examiner at the USPTO, and it does have a more formal structure. It can be the initial filing. You don't have to have a provisional, but as I mentioned just a second ago, a provisional can convert into a utility. So a utility can claim priority to that provisional's filing date. Or utility applications, they can cover a wide variety of subject matter. While mechanical applications are often what people immediately think of, such as this figure here, they really cover a wide variety of subject matter, such as software, business methods, biotechnology, and other methods in composition. So it can cover a lot of ground. Utility patent applications are considerably more expensive than a provisional. Given that there are those formatting requirements, they're more extensive disclosures than a provisional needs to be. And there are fees associated, of course, with responding to office actions. Every office action you get, you have to file a response. So there'll be some fees there. And then finally, if you are able to receive a patent, if it is allowed, there are maintenance fees due 3.5, 7.5, and 11.5 years after the patent is granted. So I will go into some more detail about utility applications in just a moment, but I just want to first cover quickly design and plant patents as well. So a design patent is another type of patent. These are less common than utilities, but still relatively common. And they cover the ornamental designs of a manufactured item. Whereas a utility patent covers how an invention functions or is used, a design patent simply covers how the object looks. It covers the appearance. If you think about it, let's say a chair is obviously old technology. Everyone knows how a chair works. You can't patent the function of a chair. However, there may be instances where you have a particular ornamental design associated with the chair that could be protected. Another example is shoe companies. Shoe companies often will file design applications for their shoes. Shoes, like a chair, obviously well known. The function is not anything that's necessarily novel. There's a lot of ornamental design that is associated with the shoe that can be of value. And so a shoe company, for example, will obtain design patents with the intention of protecting themselves against knockoff companies who may otherwise come in and just simply copy the design. Another example is a soda bottle, for example, the Coca-Cola bottle. If you think of that, most people will immediately know what the shape of a Coca-Cola bottle looks like. You won't be able to necessarily patent the function through a utility application. But again, with a design patent, you can protect the ornamental design. Just to give a real world example of the value of a design patent, you may remember several years ago, there was ongoing litigation between Apple and Samsung, where Apple asserted several utility and several design applications or patents against Samsung in regards to their smartphones. Eventually, it was determined that Samsung did, in fact, infringe both Apple's utility and design patents. However, Apple only received a $5 million judgment for its utility applications, whereas for its design patents, it received $500 million. So that's a good example of how there can be significant value in these design patents. Design patents, one last point, they do tend to get awarded much more quickly than a utility application, often in less than a year, 6 to 9 months. They have lower filing fees, and unlike a utility application, there are no maintenance fees once it's granted. And finally, just to briefly touch on this, there are such things as plant patents. These are really a specialty unto themselves. I just wanted to briefly mention them. Generally speaking, the plant must be reproduced asexually, for example, through a seed, through cuttings, through grafts or bulbs. Tubers such as potatoes are not eligible, whereas algae are. And transgenic plants such as Roundup Ready soybeans, they're actually covered by utility applications rather than plant patent applications. So jumping back to utility applications, although the US patent system previously had a fairly generous 1-year grace period during which certain disclosures could be made, which would not be considered to destroy the priority of an application. About 8 years ago, the American Invents Act was passed, which really made steps in terms of standardizing the US system with other international systems that were more of a first to file system. So currently under the AIA, if you have two inventors who independently conceive of the same invention, the first to file will almost always be the one to essentially win out. The exception to this would be if you have someone that files an application, but they obtain that by virtue of misappropriating the information from the other party. But that's obviously not particularly common circumstance. A patent requires eligible subject matter. There are set categories of what is considered eligible. Processes, machines, articles of manufacture, and compositions of matter are eligible. This covers a wide variety of inventions, such as mechanical devices, pharmaceuticals, methods of manufacturing, methods of using compositions, business methods, software, many others. Laws of nature, however, along with physical phenomena and abstract ideas, are not patent eligible. For example, if you have a method claim that involves mental steps on the part of the individual practicing the method, that would be considered an abstract idea and not patentable. Another requirement is that the patent be useful. It has to have utility. This is generally a very low bar. Most inventions it's self-evident what the utility is. However, for certain categories where it's not immediately apparent what the use would be. For example, with pharmaceuticals or chemicals, there needs to be some showing of the use of that invention. Generally speaking, the more unpredictable the field of art of the invention, the greater the disclosure needs to be. An invention must also be novel. So what that means, it has to be new. It has to be such that it's not previously disclosed publicly, either by the applicant or by another party. For example, if I were to file an application for a new type of light bulb, but there was a publication I wasn't aware of that 6 months earlier described the exact same light bulb, it doesn't matter that I'm not aware of that previous publication. It still serves as a bar, a novelty bar to my application. Now, all of this is judged on the claim language itself. So just to harp on this again, the claim language is critical, and novelty will be assessed on whether a single reference discloses each and every limitation that is present in a given claim. Another requirement is that the patent claims not be obvious to a person having ordinary skill in the art. Ordinary skill in the art is assessed based on the field that the invention is in. So for example, if you have an invention for a viral vector, the person of ordinary skill in the art may be a virologist. So it'll incorporate all the knowledge a typical virologist may have. And so for obviousness, this tends to be the examiner's, in my experience, the examiner's favorite tool for trying to reject patent claims. They can take as many different references as they want and combine them together to result in the claim limitations. So this can be a tricky thing to overcome, but there are a few ways to fight back against this. You can argue, for example, that the references, when combined, don't actually result in the patent claims that you are presenting. Another argument you can have is that one or more of the examiner's references actually teach away from combining the references together. Another approach is citing what are known as secondary considerations. So for example, you could show that the claimed invention solves long felt but unsolved needs. You can show commercial success, copying by others, and other factors to try to overcome the examiner's what we call hindsight bias. It's not always successful, but you have to try everything you can to obviously get around these obviousness-based rejections. It's a very fact-intensive based exercise. So a good understanding of the subject matter and understanding of the subtleties between the cited references and your application is critical for getting around these rejections. So in terms of, what does a typical timeline for filing and acquiring a patent look like? In terms of the actual process, here's just a simplified timeline. Of course, it begins with the actual conception of the invention itself. Now, invention it's determined based on a claim-by-claim basis. So you may have 20 claims in the application, but claims 1 through 5 may be from inventor 1, claims 5 or 6 through 10 maybe through inventor 2, and so on. Or it can be multiple inventors on the same claim. Assuming the inventors or inventor feel that this is worth pursuing, they may refine their inventive concept into a prototype. They may perform a prior art search. They may assess the field to determine whether it's even worth filing in the first place. To jump first to the prior art search, there are a few different philosophies here. Some people prefer to perform it, others prefer not to. The search can be as broad or as narrow as you want. Obviously, the broader the search, the more expensive it will become. So it can sometimes come down to cost. Some people just don't simply want to pay the fees for a search firm to perform the search. Others, however, prefer not to perform the search due to the reason that if you come across a reference before you file, but you think that, oh, this does not read on my claims, but later it's determined that you do infringe on, if that reference is a patent, if you do infringe it, if it's determined that you were aware of this patent and pursued it anyway and practiced the invention, you can be considered to perform willful infringement, which will lead to enhanced damages. So some people prefer to put their head in the sand, so to speak, and not look at what's out there. Others, conversely, do prefer to check it out. Regardless, if the inventor wants to move forward, They must, of course, prepare the patent application. Now, I've mentioned some of the requirements for patentability already, but just in terms of the scope of the disclosure, there are a few others that have to be met as well. The disclosure must be sufficient to demonstrate that the applicant was in possession of the invention at the time of filing. In other words, it needs to be a sufficiently detailed disclosure that would allow the third party to perform the same or practice the same invention without having to go through what they call undue experimentation. So for example, if you have an application directed to using a viral vector to treat a given disease, you would have to show and disclose what vectors could be used. You would want to show some examples of the vector being used, of the vector's efficacy, sufficient to show that you actually do have possession of this particular invention and that a third party could practice the invention without having to go through too much experimentation themselves to be able to practice the same invention. Once the application itself is filed, it takes about 1.5 years before it gets published. There are ways to prevent publication for certain sensitive matters, but generally in about 1.5 years it will be published. And in about 1.5 years, the examiner will issue a first substantive office action based on the merits of the claims. Before that, however, you can get certain preliminary office actions. For example, if you submitted figures that were too blurry, if you had any missing parts, the examiner will issue a notice of those deficiencies and give you time to correct them. Also, the examiner may issue what are known as restriction requirements, where they may allege that what you're claiming is actually more than one patentable invention. Generally, this has to pertain to whether the examiner will have to perform 2 sets of prior art searches, because the subject matter of the claims, one set of your claims is vastly different from another. This often arises where you are claiming both a product and a method relating to that product. Sometimes you can get around and argue against this restriction by showing that the claims involve very similar limitations, that there wouldn't be the need for the examiner to perform a vastly different set of searches. But to the extent you are forced to pick one set of claims versus another, you would then withdraw the other set of claims, which could then be pursued in what's known as a divisional application, which can be filed anytime during the pendency of the parent application and claims the same priority date. An application, once you get to the substantive office actions, an application will almost always get at least one rejection. Now, the reason for this is most patent practitioners will draft the claims in a way that's perhaps broader than what you think you'll end up getting. So it's a bit of a game where you claim more than you think you would necessarily get, but you do so aggressively with the expectation the examiner will come back and want some concessions. And so this gives you a means by which you can concede to the examiner, give up some of that extra subject matter that you really didn't necessarily care about, but really focus then on your core set of claims. And so depending on whether you can overcome the rejections of your claims, be it under a novelty rejection, non-obviousness rejection, or another rejection, if you're unable to overcome that, the examiner will then file what's known as a final office action, which will then require you to either file an RCE, a request for continued examination, which then resets the prosecution, or you can file an appeal, which will then take the matter to the Patent Trial and Appeal Board for adjudication there. If you don't obtain the result you want during appeal, you can then again file the RCE and reset prosecution. Alternatively, and hopefully, if the claims are allowed, the patent will then be granted and the patent term will then run until expiration or abandonment for failure to not pay maintenance fees. If also during the pendency of the application or the patent, if you have any new matter that you want to claim that relates to the original subject matter, you can file what's known as a continuation in part application as well. So that's just something to keep in mind. So far I've been talking about patents in the United States, but of course there's the whole world to consider. There are valuable markets in Japan, Europe, the rest of Asia, Australia, and Canada, India. So depending on the product or service, it may be worth pursuing patent protection, not just in the United States, but also in these other jurisdictions. So there are a few ways to go about this. You can, simultaneously with your US application, you can file in these other countries. That's a big expense up front. It's cumbersome to file. And so what a lot of people do is instead file what's known as a PCT application. So PCT stands for Patent Cooperation Treaty. There are more than 150 countries that are party to the PCT. This allows you to file an application through what's known as the International Bureau. In the US, you just file it through USPTO, who files it on behalf of the International Bureau. And this allows you to indicate which countries you want to potentially pursue for your application. It's almost like an international provisional, in that it gives you a 30-month window during which time you can decide whether to later enter into those national stage applications. An additional benefit of the PCT application is during those 30 months, the International Bureau will perform an initial search report. They'll give you an initial search report, which will list any prior art they discover that may be relevant. And they'll also issue an IPRP, an International Preliminary Report on Patentability. And so this is almost like an initial office action in a way that will clue the applicant in as to whether there's troublesome prior art out there that may make getting these claims allowed difficult. So if you do decide that you want to, within those 30 months, if you want to pursue the national stage applications, you can then pursue one or more of the nations that you indicated. You don't have to pursue them all, but you can pursue any number of them in what are called national phase applications. Europe also has a somewhat similar system, in the sense you can obtain you can file a single application through the European Patent Office rather than go and file in each individual country, which obviously is quite cumbersome and difficult. And so by filing it in just the European Patent Office, again, you can designate individual member countries. And if it's examined and allowed at the European Patent Office, you can then get those claims validated in each individual country. So it's still expensive, but it's a simpler, less expensive way of obtaining patent protection throughout Europe. So I've talked now about patents. Well, what about trademarks? They're another form of IP that, although perhaps less complex than patents, they can be quite valuable. So trademarks they're really a consumer-oriented IP right. They, as I mentioned earlier, they're intended to allow consumers to quickly identify the source of particular goods and services. Trademarks can come in several forms, such as brand names, logos, slogans, and designs. For startups, trademarks are important for establishing the branding of the company name itself, as well as the branding of any crucial goods and services that are offered by the company. So trade dress can protect the appearance of a product, packaging, or even a store, and may include features such as shape, color, texture, and size. Trade dress must be distinctive and non-functional. A feature will be considered functional if it is essential to the purpose or use of the product, or if it even affects the cost or quality of that product. To be distinctive, trade dress must be inherently distinctive or acquire secondary meaning to become distinctive in the eyes of consumers. Inherently distinctive is a pretty high bar. It's not applicable to product design, tends to require unique, unusual, or unexpected design features that allow a consumer to automatically perceive the company of origin. Trade dress is often not inherently distinctive, and it requires time so that it can acquire secondary meaning with the public. Factors showing secondary meaning include the length of use of the trade dress, whether there's been commercial success, the amount of advertising, feedback from consumer surveys, as well as media coverage. Trade dress can cover colors, such as pink Owens Corning insulation. You think of the Pink Panther insulation commercials, or yellow Splenda packets, for example. These products were not initially associated with those colors, but by virtue of those other factors that I mentioned, over time, the public, the consumers began to associate those colors with the products, and the trade dress was established. Like with the Coca-Cola bottle, for example. Day one, it may not have been associated with Coca-Cola by consumers, but over time, the shape became recognizable and protected as a trade dress. Although trademark registrations can be obtained for scents and sounds, this is relatively rare. To give an example of a scent that's protected, Play-Doh, that's a good example. Everyone, or most people, will quickly recall the smell of Play-Doh. That's one that's been protected. In terms of sounds, that's also relatively rare, but some common examples of sounds that have been protected include the NBC chimes, the roar of the MGM lion that plays before a movie, or another one is the Intel Inside jingle in the commercial. So a trademark arises from the actual use of the mark in commerce, and it doesn't require registration. So if a mark is used in commerce without obtaining federal registration, the user will get what's known as common law rights. Those rights are unfortunately quite limited compared to the rights you would get through federal registration with the USPTO, however. So registration is generally recommended, whereas common law rights protect use of the mark within the geographic area that is currently being used. For example, if I'm using the mark in Huntsville, I may get common law rights, within the Huntsville-Madison area, or perhaps the North Alabama area. Whereas if I were to obtain federal registration of that trademark, I would immediately get nationwide blanket coverage for that mark. Federal registration also allows the use of the circle R symbol, which gives notice to third parties that the mark is in fact registered. If the mark is not registered, you can put the little TM sign next to the mark to let people know that it's at least got common law rights. But at the same time, it's a bit of a double-edged sword because it also shows that you don't have the federal registration yet. Federal registration allows the trademark owner to file in federal court and to potentially get triple damages for infringement. Also, in the event an infringer is producing counterfeit goods using your registered mark, you can obtain statutory damages instead of having to prove actual damages, which can sometimes be tricky. Another benefit is that you can coordinate with U.S. Customs to prevent the import of any infringing counterfeit marks. And finally, once the mark has been registered for 5 years, it becomes known as what is incontestable, so that if the validity of the mark is challenged, the challenger will have far fewer options to overcome the assumption of validity. And also, if the mark is registered, of course, if someone else attempts to register a confusingly similar mark, the examiner will hopefully see that the mark has already been registered and deny registration for that reason. The registration process itself is far simpler than a patent application, and it's far cheaper. You pay, right now, I believe it's $275 per mark per class. So for example, if you have a mark and you want to apply it to luggage and clothing are in two different classes of goods. So you would have to pay a $275 fee in each class. When filing, you have to provide the mark if it's a word mark, or the logo if it's a design mark, the date the mark was first used in commerce, and a specimen showing the use of the mark as it's being used in commerce, and then a description of the goods and services. If you're not yet using the mark, you can still file using an intent to file application. You would just need to later file a statement of use and a specimen showing that use. If the mark gets allowed before you begin use, you can file 6-month extensions up for, I believe, 2.5 years. But of course, that requires an additional fee. So in terms of the timeline of trademark prosecution, usually within about 3 months, the examiner will begin looking at the application. And typically we'll issue an office action. Sometimes it's just to correct some of the wording in the description. Sometimes, unfortunately, it's because they believe it's confusingly similar to another mark. In either case, you'll have to respond within 6 months to that office action. If you're able to overcome the office action, the examiner will then publish the application in the USPTO Gazette, which gives third parties the opposition to see that something is pending registration, and they may oppose registration. If there's no opposition, or if the opposition is cleared and settled, the mark can then become registered. The mark can survive indefinitely, unlike a patent. A mark can survive as long as it continues to be used in commerce, and so long as you continue to pay periodic maintenance fees. To register a mark with the USPTO, a mark really needs to be distinctive. And so when assessing a mark for distinctiveness, it really exists on a spectrum. From least to greatest distinctiveness, you have generic, descriptive, suggestive, arbitrary, and then fanciful marks. Generic and descriptive marks are not considered distinctive and are not considered protectable under a trademark application. However, suggestive, arbitrary, and fanciful marks can be protected. So a generic mark is literally what it sounds like. So it describes the product. So computers, if you had a computer product and you called it computer, that's generic. You can't protect a generic term. Moving along, if you have a descriptive term, that's also not protectable. So for example, if you have a brand of knives and you call it Sharp Knives, all that does is describe the product itself. So that's descriptive and not distinctive. If you move forward, however, and you get to a suggestive mark, a suggestive mark is something that maybe hints at what the good or service is, but it doesn't explicitly describe it. So for example, copper tone. Copper tone is a suggestive mark for sunscreen. It kind of hints at what the product may be, but it doesn't explicitly say what it is. Arbitrary marks, those are where you use a common term, but one that wouldn't necessarily be thought of to apply to that product or service. So for example, Apple computers. You wouldn't think of an Apple with a computer, but obviously, it's associated now with those computers. So that's an arbitrary mark. And finally, at the most extreme end of the spectrum of distinctiveness, you have fanciful marks, which are really just invented terms such as Kodak or Xerox, which have no meaning whatsoever except in relation to the good or service. Now, just to go back for a second to descriptive marks, although they can't be protected on the principal register, they can potentially be put on what's known as the supplemental register. So the supplemental register is where you're unable to demonstrate that distinctiveness at the time of application, and you don't get the presumption of ownership of a valid and enforceable trademark, but you do get the benefit of the mark being on file with the USPTO. It may dissuade others from attempting to file a similar mark. You still get to use the Circle R designations. That's another benefit. And you can eventually try to register that mark on the principal register if you can show that the mark has acquired secondary meaning. So secondary meaning means that you can show consumers have begun to identify that descriptive mark with the origin, the source of those goods or services. And factors that will determine whether you've acquired that secondary meaning include consumer testimony, consumer surveys, exclusivity of use, the length and manner of your use, advertising, sales numbers, number of customers, your market presence, and proof of others attempting to copy the mark. So if you're successful, it is potentially possible to get this on the principal register and then enjoy the full benefits of registration. So I mentioned patents, I mentioned trademarks. Now I'd like to talk a little bit about copyrights. These are far simpler than a patent or even a trademark, but they can have substantial value to a company under the right circumstances. So most people have a sense of what a copyright is, but just to be specific here, a copyright protects original works of authorship that are fixed in a tangible medium. It can't be, in other words, it can't be just an idea. It has to be in a tangible form. And it has to have some degree of originality to it. Originality in this case is a pretty low bar. You can't have a mere listing of information such as a recipe or a listing of phone numbers in a phone book, for example. But conversely, how the recipe is described or how a particular collection of recipes is compiled can be considered sufficiently original to be protected. So a copyright gives the exclusive right of the author or the assignee to make copies, prepare derivative works, and publish the copyrighted material. The author, the original author, will be considered by default to be the owner of the copyright, unless the work is created through employment or in a work for hire type arrangement for a contractor. In terms of the lifespan of a copyright is considerably longer than a patent. It can either be the life of the author plus 70 years or the lesser of 95 years from the date of earliest publication or 120 years from the date of creation of the copyrighted material. The very first Mickey Mouse cartoon, Steamboat Willie, for example, that was put out almost 100 years ago, but it's still protected by Disney under copyright. So these rights last for a very long time and give the owner a lot of potential value given the extreme lifespan of these copyrights. Many different types of works are protectable by copyright, including literature, music, dramatic works, choreography, graphic, sculptural works, video, sound recordings, and architectural works. A single work, such as a movie or a piece of music, can actually have many different copyrights associated with it. If you think in the case of a movie, you have the script, so the screenwriter will have perhaps a copyright to the script. You may have a soundtrack, so there'll be music involved. You may have songs, so there'll be lyrics involved. You'll have the video itself. So there are a lot of different, the rights may be associated with a single work. And so when it comes to licensing those works, things can sometimes get a little complicated. As I hinted at earlier, not all work is protectable by copyright. Perhaps most relevant, systems, methods, processes, and ideas. Those are more the realm of patent protection and are not protectable by copyright. So a copyright is actually created automatically as soon as the work is created. You don't have to register to create the copyright. That being said, registration with the US Copyright Office is required to really fully benefit from the copyright. The application itself is straightforward. It only has a modest fee. So there's not a lot of involvement there. It really just involves submitting a copy to the Copyright Office along with a fee and some basic information. The fee itself is less than $100, so it's not a complicated or expensive endeavor. The primary benefit of registration is that it allows you to bring an infringement action in court. It also serves to establish ownership of the work after 5 years, such that the work, if registered for 5 years, will be considered, it will be assumed that the registrant is in fact the true owner if it goes to litigation in the event of a dispute. Registering the work as soon as possible is also beneficial. If the work is registered prior to an infringement or within 3 months of first publication, the owner can seek what are known as statutory damages. Statutory damages are set amounts that the owner can claim. They don't require the proof of actual damages, which often can be very difficult to prove. And in many cases, those statutory damages can add up to significant amounts. So there's a huge benefit to having the early registration to get those damages. Registration prior to infringement also allows the owner to seek attorney's fees and other costs associated with enforcing the copyright, as well as to work with the U.S. Customs to prevent the import of infringing goods. So finally, I've talked about patents, I've talked about trademarks and copyrights. I just want to briefly talk about trade secrets. These are the last form of IP I'll be talking about today. So as the name indicates, trade secrets are secret. They are secrets that a company has relating to business, financial, and technical information that is kept confidential by the company using reasonable efforts. And the information has to be economically viable, or valuable as well, because the information is not generally known. When I say reasonable efforts, I mean measures such as physically restricting access, digital security measures such as encryption or password protection, as well as prohibiting non-confidential disclosures of the information. Obviously, if the information gets out to the public, it's no longer a secret and can no longer be a trade secret. Some classic examples of trade secrets include the Coca-Cola recipe and the KFC fried chicken recipe. These are obviously, at this point, more marketing tools than anything. Typically, trade secrets of a company will involve their business plans, customer lists, know-how, standard operating procedures, and so on. Unlike other forms of IP, as I already mentioned, trade secrets are not registered. They're instead protected by virtue of being kept secret by the owner, and the owner can do so indefinitely. Unlike other forms of patent protection or IP protection, trade secrets can be protected indefinitely. The flip side of this is that, of course, a third party can come along and independently develop the same idea, in which case, your luck runs out, so to speak, and your trade secret may no longer have value. So for many, a consideration will come into play for an invention as to whether it's worth seeking patent protection for the idea or whether to maintain it as a trade secret. And I'll get to that in just a moment. So to briefly go through some considerations for protecting intellectual property, I've talked about the different types, but how do you decide what form is most appropriate for your IP? I'll get into more detail in each of these different considerations, but these considerations include what, when, and where to file. By what, I mean what type of IP protection will you seek? Will you seek patent protection? Will you seek trade secret protection? By when, I mean, when is it best to file? Do you want to file the trademark right away? Do you want to file the copyright right away? By where, I mean jurisdictions in which a filing is made. Do you want to file only in the US, or do you want to file in Europe, or do you want to file in Asia? For a patentable invention, for example, the invention may have value in certain markets, not in others. And so you want to carefully decide which markets are worth pursuing patent protection in. Another consideration is the need to maintain confidentiality. Certain agreements should be in place to protect the company's IP, and inadvertent disclosure should be avoided. Another consideration is whether trade secrets are adequately protected by the company. There are certain proactive measures the company will need to take to ensure that information will in fact be considered a trade secret if it were to reach litigation in court. And finally, I'll discuss a few considerations for enforcing various IP rights. In terms of patents, just because an invention is patentable does not necessarily mean that a patent is the best form of protection. Trade secrets can sometimes be the more suitable choice. A patent is expensive to maintain. It can take 3-4 years to obtain, and it requires full disclosure to the public of how to practice the invention. If an invention can be used commercially without making it susceptible to reverse engineering, then it can actually make more sense to maintain it as a trade secret rather than file a patent. This will save you time, it'll save you money, and potentially extend the life of your exclusive use. A good example of this is Elon Musk with SpaceX. He was asked at one point why he didn't file patent protection for his rocket designs, and he said, well, by doing that, I have to give a detailed disclosure of the whole design of the rocket. In some jurisdictions, the enforcement may not be respected. Other countries, China is one example where sometimes enforcement is not as strict as some people may like. But also, even within the US, even if you do obtain enforceable patent protection, once the patent expires, others can then copy the design. In the case of SpaceX, he may feel that, hey, no one else is going to get this rocket design. I don't sell the rocket to a third party. People pay me to put their payloads on my rockets. No one's ever going to see the inner workings of my rockets. So I'm just going to maintain this as a trade secret. And so that's a viable approach of choosing one versus the other. If filing another patent, another consideration is where to file. As I already mentioned, the PCT application is one way to buy some time to decide which jurisdictions you want to pursue. Depending on the invention, some jurisdictions may be more valuable than others. Although, of course, multiple jurisdictions will involve additional expense for filing and protecting. You may be leaving money on the table if you don't obtain that protection in certain jurisdictions. In terms of filing for trademarks, it's critical, especially as a new company, to determine whether a mark is available before you begin branding. A survey of marks that are already in use can be relatively inexpensive and relatively quick to perform, and will prevent headaches down the road. As you can imagine, going through the whole branding process and then getting a year or two down the road only to receive a cease and desist letter in the mail from a registered trademark owner is not a situation you want to be in. That's a far more expensive process to have to then rebrand or license the mark from the third party than it would be to perform that initial quick search and pursue a branding scheme that is far less likely to infringe on a third party's rights. Another thing somewhat related to this to check before proceeding is the availability of domain names. So if you determine a brand name you like, always check to see if there's a suitable domain name that's available for use. Obviously, in today's market, having a decent domain name is an important consideration. So in terms of copyrights, pros in favor of whether to file are, of course, that it's very cheap to file. It's a very simple process. It's less than $100. Registration can be obtained quickly in less than a year. And by registering, you get several benefits that I already mentioned in terms of enforcing this in court, as well as the availability of certain damages in the event you file promptly, either before infringement or within 3 months of first publication. Really, one consideration is whether the work itself has any commercial value. An employee handbook, for example, it could be registered as a copyright, but really is there commercial value there worth protecting? Perhaps not. Whereas something like a training manual, it may have value to other companies, it may be worth protecting. If you have software, a consideration comes down to source code. If you file a copyright for software, you're gonna have to reveal, perhaps not all, you can redact some portions of the filing, but you're gonna have to reveal some of your source code. So for some software, if it's offered as a software as a service where the software is hosted exclusively on your servers, where a user will not have access to that code or otherwise will not be able to readily reverse engineer the code, it may be worth not filing a copyright and instead just maintain it as a trade secret. So apart from filing considerations, another important consideration when it comes to IP is how to protect confidential information. This is typically handled through standalone confidentiality agreements, non-disclosure obligations within those agreements. It can typically be achieved through non-disclosure agreements, NDAs, sometimes known as confidentiality agreements. So if you're a company and you're going to be engaging in a potential transaction with another company, if you're going to be exchanging any kind of confidential information, the very first thing you do before you move forward with any discussion is to quickly sign an NDA. In terms of a company's employees and contractors, you can have the standalone agreement, but typically you would incorporate those confidentiality obligations into the employment agreement or the consulting agreement itself. Even if you have those agreements in place for employees and consultants, it's important to educate the employees and consultants on avoiding non-confidential or inadvertent disclosures. In the case of a patent, for example, if you accidentally disclose patentable material before it gets filed, that can serve as a bar to patentability. Similarly, if you inadvertently disclose trade secrets without any confidentiality obligations, they become public knowledge and can no longer be protected as trade secrets. So once you've secured your IP rights, what's next? Well, part of the motivation for obtaining those rights, of course, is to carve out space in the market by excluding others. So if a third party begins using your IP without a license, those rights should be enforced if you have those rights. One problem with this is identifying the actual instances of potential infringement. If you have a registered mark, but you're only using it in Alabama, and if a third party, a small company, begins using it in Nevada, how would you know? Part of the problem with trademarks is you do have to enforce your marks. You have to maintain the quality so that the mark is consistent in the eyes of consumers. If not, the mark can actually become invalidated. So one way to do this is to routinely perform web searches for your mark to see if anyone else is beginning to use your registered mark. Another way, if you don't have time, is you can actually hire third-party search firms to periodically search for other companies that may be infringing on your mark. In terms of enforcing patents, a patent owner will typically issue a cease and desist letter to the alleged infringer, sometimes with an offer to license the patent, particularly if you're dealing with a patent troll where they don't care about using it themselves. They just want to extract money from those who are using the technology. If the alleged infringer refuses, the patent owner can then assert patent infringement claims in federal court. Patent litigation, however, is very expensive. It often costs millions of dollars just to prosecute. And for that reason, instead of litigating, parties will often settle either by ceasing use of the technology or by licensing the technology. So finally, I just want to talk quickly about some common pitfalls that companies will encounter as it relates to their IP rights. So companies will often obtain IP that's created not by the company itself, but rather by third-party contractors and consultants. Generally speaking, absent some agreement, that IP will not belong to the company. The company may get, by virtue of the consulting agreement, an implied license to use that IP, but it won't prevent them from stopping the contractor from owning the IP or licensing it to others. And that can obviously pose a problem. Let's say you've developed software, you've paid a contractor to develop software, but in the agreement you failed to have an assignment or a work for hire provision to convey those rights to you. Well, the consultant can later turn around and then license that same software that you've paid for to other parties and continue to benefit from your expense. So that's why, and that's a real world example I've seen. So it's critical in your agreements with these third parties to have what's called a work for hire provision to convey those rights to you, as well as a general blanket assignment to the extent anything is not considered a work for hire, that the IP will also be assigned automatically. In terms of a company's employees, the company will generally be considered to be the owner of the IP that's created in the course of employment. That being said, it's better to be safe than sorry, and we would generally recommend having similar IP assignment provisions in the employment agreements just to be sure. For example, you want those provisions to be as broad as possible such that any IP that's generated related to their employment, whether or not they're even at the office at the time, during the term of their employment will be considered the company's intellectual property. You also want to have the employee covenant in their employment agreement that any IP they create for the company will not incorporate any third-party IP. You don't want to have your employee create something only for another company to come in and then sue you because that employee used their intellectual property as part of what they developed. To avoid any misunderstandings, if you have an employee that's coming in who's perhaps has a long history of generating IP, in the employment agreement, you can have the employee list any pre-existing IP that won't be obtained by the company, just to avoid any confusion later on. And finally, just to ensure that all IP is captured by the company, it's generally a good idea to have a disclosure process in place, typically outlined in an employee handbook. This typically involves the use of an IP disclosure form. It's just a 1 or 2 page form that allows employees to periodically disclose anything that they think may be protectable. So you'd want to have them disclose generally what the idea is, when they thought of it, any related IP that they're aware of, and whether any public disclosures have been made. And then to submit that form periodically to IP counsels for review to assess whether anything's worth pursuing. Obviously, a big concern that companies will have is potentially infringing a third party's IP. You don't want to build a website, establish a brand, or launch a product or service only for a third party to send in a cease and desist letter alleging that you're infringing on their IP. So as I mentioned earlier, one way to avoid this is to have third-party search firms perform an initial search before you establish any of these products or brands. So that may give you a clue up front as to whether you may potentially infringe. This is true for both patents in terms of potentially infringing any third-party patents, as well as trademarks in terms of branding. It's far cheaper to check up front than to, obviously rebrand or have to abandon something you've put a lot of time and effort in years down the line. Another common problem that sometimes arises is in terms of the company's website. You want to be careful that any video or photos that are incorporated into your website are properly licensed or owned by the company. Often someone developing a website will just go on Google image searches and pull in a photo. That photo will often have a copyright associated with it that's been registered, and a third party will come in and demand that you then license that photo and seek damages. There are a number of open source, freely available databases of free stock photos or even stock photos with a very small licensing fee. So it's worth just paying that small fee, if any, upfront to avoid those damages down the line. When dealing with software, in today's market, there are a number of open source components that are often incorporated into that software. These open source components can be very useful, but they're not necessarily without risk. Each open source component will have an open source license associated with it. Not all open source licenses are the same. They exist on a spectrum of restrictiveness. So some may just require that you include notice that you're using that open source code. Others, however, particularly GPL 2.0, they actually require, if you incorporate their open source code into your proprietary code, you'll have to then disclose that all of your proprietary code as well to any consumer that purchases your product that incorporates the open source code. So that's obviously something to consider and worth checking out before you incorporate that open source coding into any product you'll be releasing. And finally, there are a few considerations to keep in mind with trade secrets. I mentioned this before, but it's worth reiterating. There are certain proactive steps that need to be taken. If you have, let's say, know-how or customer lists, but routinely disclose that information to third parties with no obligation of confidentiality, or do not mark the information as confidential, then you're going to have a hard time arguing in court that that is in fact a trade secret. Similarly, you need to have password protection on your devices. And one common pitfall that I've seen in many court cases is if a company issues devices to its employees, but then doesn't get those devices back or otherwise doesn't require the employees to return or destroy the sensitive information, that will destroy the information as being a trade secret. So you want to have all of these protocols in place to proactively protect this information to ensure that you maintain trade secret rights. And one last point on trade secrets. Several years ago, the Defend Trade Secrets Act was enacted. And to preserve certain trade secret protection rights, you need to include a certain disclaimer. It's only about a paragraph long in all of your employment agreements. And what this does is simply say that an employee can disclose your trade secrets only to the extent required that they believe they are disclosing a potential illegal act or otherwise there's a suspected violation of law. As long as you have that notice, you're able to obtain certain exemplary damages and attorney's fees in the case of misappropriation. If you don't include that in your employment agreements, then you won't be able to pursue those remedies. So with that, I want to thank you for listening. Of course, this is just a very broad overview of various IP rights and some considerations that come into play. If you have any more specific questions or any issues that come along, of course, feel free to contact me. I'd be happy to help anytime. Thank you for your time.